So this is the regularly scheduled Town of Nantucket Board of Appeals meeting, November 8th, 2018. Can I get a motion to approve the agenda as written? Okay.
Seconded.
Any further discussion? No. All those in favor say aye.
Aye.
What about the minutes of October 11th, 2018? I have to admit I did not get a chance to read those, so if someone else did and feels that they're good, or we can pass them on. The next,
Wait till the next meeting.
next meeting? All right. Didn't do the minutes. Okay. All right, so can I get a motion to, do we even have to do anything if we don't?
You just have to make a motion that you're tabling them.
Yeah.
Approval for next year.
You made that motion, Michael? Is there a second?
Second.
Lisa seconds it. All those in favor say aye.
Aye.
Okay. So, old business. This one's Act 1918 Act Crazy LLC, 9 Westchester Street. Uri Venkat. No. Okay.
For the record, Attorney Arthur Reed, this case has been continued a number of times. The issue being pending the execution of an agreement between the abutting property owners, whom I represent, and the applicant, who had been not represented by counsel through the proceedings, but who was represented for purposes of working out an agreement with the abutters by my brother, Mr. Cohen. In any event, we have worked out the agreement. Last night, we agreed to final change in the agreement after Mr. Cohen became involved in getting it finalized. My clients agreed to. I believe that the board was awaiting that in order to be able to grant the applicant the requested relief. And with that agreement having been signed by Mr. Cohen's client, we are comfortable with the decision being entered for the relief that was requested by the applicant, and would encourage you to go ahead and grant that relief.
Okay. Thank you. Do we need to see the agreement? That's would be part of.
I don't think so. I don't think it needs to be in the record. The question of would there be an agreement, and there is an agreement. It's been signed by Mr. Cohen's client. My clients will go ahead and sign it now. There are other provisions in there that go beyond what the ZBA decision would cover. But I think the only thing that we would request would be that you apply your usual conditions about the timing of work, which we have a separate agreement as to anyway, and that the work be done in accordance with the recommendations of the engineer's report that is in the that's in the file.
Arthur, our staff report indicates that the board was looking for a written agreement signed by both the abutter and the applicant to be submitted to memorialize the access and that sort of thing. Are we going to basically waive that?
I would say.
I think you're right, and you've got a good point, and I would think it would be part of the decision myself.
Yeah, so would I.
Could be in the file, but not an exhibit.
Well, I think that's a little bit of a slippery slope, because there are private matters that shouldn't necessarily be either attached to the decision or in the public record. I mean, I think if the parties have represented that they have an agreement, that should be sufficient for the board.
Why can't you just have two agreements? One that's top secret and one that is we can attach to the decision like we asked.
I just have like a letter agreement between the two of you that says about the things that are pertinent to the ZBA.
Okay, we can
Right.
certainly submit a letter agreement that Arthur and I would both sign, that our clients have come to an agreement regarding this matter, and that Arthur's clients assent to the relief. Is that
Well,
sufficient?
I think it would
specifics,
outline
right?
the things that they've agreed to,
Yeah.
the timing, et cetera, et cetera.
Yeah, just you could reference that. So you could say something like this is the parts that are relevant to the ZBA, and reference the private agreement.
We don't even care
that
about
you
that.
don't want to disclose.
Yeah.
We don't care
I mean,
about
there's
fines
nothing
and things
particularly
like that.
private in this agreement, but I think it's a little bit dangerous for the board. I don't know that the board has ever required private agreements to be filed with the.
We have.
Definitely.
Yeah, we
No,
In this
there's
kind
no
of
question.
situation where it's the
Absolutely.
neighbor so close, we have.
absolutely.
Do you care?
I would prefer, I don't think we want to get into, one thing is compensation being paid.
No, we don't care
I
about
don't
that.
think we want to get into.
We don't care about the
specifics about
compensation.
Other people,
I suspected
use
that,
as a-
but I don't
as-
think
as
it's,
as a precedent or anything like
No.
that.
No.
No.
I think
No.
that having the side letter on the terms that would be of interest to the ZBA.
Yeah, just,
would
we
be-
only care
would be
about
appropriate.
access and the safety,
Right.
safety and.
Timing, any, yeah.
Yeah.
Christmas decorations, stuff like that.
Okay, I'm sure Arthur and I can pull the relevant terms. I mean, there's stuff about access because we're right up on the boundary, and there's stuff about timing of construction and those kind of things. So we'll do a letter agreement between the two of us that can go to the file.
Because those are the things we just wanted to make sure the neighbor was protected, so.
If I may, through you, Mr.
Yep.
Chairman. In the past, similar situations with equal proximity and similar scope of work, we've had, the conditions have included things like the GC's number is made available to the abutter so that if there's any issue, they can be reached, things like that. So I can send that to you to give you an idea of what.
Well, we have an agreement, we're not going to change the agreement.
No, I know, I'm just saying
But-
the term, they may or may not be in the terms of your
Yeah.
agreement, but the things that we want included.
There are provisions involving keeping us informed as to what's going on.
So do we want to see that before we vote on this?
This has been-
How does everyone feel about that issue?
I'd just like to see it to make sure that there's
Like-
nothing in there that pertains to something the ZBA may or may not have said.
Okay. I mean, we have been asking for it for probably 6 months, so it doesn't seem unreasonable to
Well,
see it.
I could provide it to Eleanor to email to you now if you wanted to.
No.
The problem that
First of all, we would all,
we're-
and what, then you'd expect, that, no.
So we're also running into a timing where if my client wants to be able to get the work done so as not to disturb his neighbors when they want to be able to use the property, that work should try to be done now.
Did you have to wait until last night to come to the agreement?
Wait a minute. Did you have to wait 6 months to come to the
I mean,
agreement?
even if we had had this a few days ago, it would have been helpful.
I want to thank Mr. Cohen for his
Same.
efforts on this situation.
I was not.
What has happened on this, as you recall, is that I showed up at the last meeting and nobody was here.
Right.
And Mr. Cohen had been in contact with his client, but the client had never responded. I sent an email to Eleanor and to Stephen a couple of days ago saying that if nothing is forthcoming by today's meeting, that I was going to ask that the application be denied. And
Pick up and going.
rather than I mean, frankly, I'm sick of coming to meetings to deal with this situation and nothing happening. Stephen immediately picked up on that. And again, it's not his fault anyway. His client has been very dilatory, shall we say, in dealing with this whole situation. But Stephen brought it to a head. He made one suggestion that his client wanted changed in the agreement, namely that what we were talking about in terms of the timing of when work would be done, that be specifically for this situation rather than an ongoing restriction on the property. And we agreed. We had no intention of putting on a restriction to the property. We made that change last night. I got it out late last night after I got back from the Conservation Commission meeting to Stephen. He got it to his client. His client emailed it to him today, the signature page. I'll now go ahead and get it to my clients for their signature, but that's a given. I mean, we prepared it. They're fine with the document. I really would like to see the decision entered now that we've come to this point as soon as possible, but for the reason that Stephen mentioned, which is to get this going in the off season and get it over with. And I would hope that the decision could be voted and entered today, and that one condition of the decision could be that there is an agreement with the abutters, that there be an agreement with the abutters, and that a memorandum of that agreement, insofar as it involves issues of concern to the ZBA, would be placed in the file. And then, with that having been placed in the file, the conditions of the decision will have been met. That'll all be taking place hopefully during the appeal period, and or even before the appeal period starts. And they'll be able to go forward. I mean, we've gone this far, let's get it over with.
Deadline's tomorrow, isn't it?
For,
This application.
The action, that deadline?
well, we just get an
Yeah.
extension if we don't feel like.
No, but I mean, I'm just saying that.
Yeah, I don't think
you know,
anyone was
we
suggesting.
haven't slowed it down, and Arthur hasn't.
No, I don't think anyone's suggesting that Steven slowed it
Yeah.
down. It's the applicant drives how
Yeah.
fast this can go, and this is the first meeting I think Steven's been at
Yeah, I
for
haven't
this.
Yeah.
been
So, I don't think anyone's saying that you dragged your feet on this at all, but I would like to see it. I mean, the point is that we want to protect your client, Arthur, from the construction, make sure that the access and the appropriate precautions are taken. I, for one, would like to see what was agreed to. Usually we go through that pretty detailed to make sure that that's covered.
I mean, frankly, we're satisfied that we're protected by virtue of the agreement.
Well, we're sympathetic to that, but I think everybody has said, we've asked for it. We asked for it repeatedly. We didn't just ask for it at the last meeting or the meeting before, and it hasn't materialized. So once you get it done, show it to us. We'll agree. Well, I'm sure we'll
And we
agree
were
to
very
it.
clear with the applicant himself when he was at the meeting, when we were upstairs, whenever that was, months ago. We were very clear with him,
Yeah, absolutely.
specifically what we wanted. So, I mean, he had to know, so I understand his desire to get construction going, but that should have been a motivating factor earlier, in my opinion.
Okay, so aside from having that in hand, are there any other issues that we could address? Do you want me to remind the board of what the relief sought is, or are you familiar with it?
Go ahead and remind
It's
us.
so long.
In two senses, essentially, I think it's the west rear side of the property has a setback encroachment, and the intent is to demolish that and then replace it within the setback, but also to increase the second story aspect of it. So essentially, it's a waiver of the demolition for the setback and also an increase of the height within the setback. But there's no additional encroachment.
Yeah, I don't think anybody had a problem with this specific relief. Lisa, back in the day, you had some questions about the design that I think were answered.
Right. And was everything answered relative to the construction methodology and the foundation and the proximity and all that? They're leaving the foundation under that section of the building, is my
Right.
They
recollection.
changed that, right?
Well, and as Arthur said earlier today, it would have to be done in compliance with that engineer's report
Right.
and what they've submitted.
Yeah.
But again, I
That's
mean,
what
I
I'm
think
looking
that's
for, so
that's what.
We would expect that the conditions would include compliance with the engineer's report and compliance with the no exterior construction rule that you usually put in place.
And the engineer's report will be part of the decision?
Yeah, it's right,
Yeah.
well, it's right here,
What page is it on? 50?
50.
So
Okay.
I don't think we're prepared to throw any more curveball, any curveball, because I don't think we ever have. We've just simply asked for something that never came to us. I mean, we still haven't seen it, so. Continue? Well, first, we need
have
an
to
extension
It's right here,
till, what would the date be?
December 19th.
19.
If we were to show you the original or the actual settlement, would that do it?
No, I mean, I thought we were clear.
Okay.
How does everyone feel about it?
Well, I guess if we got a peek at it, not that it would be part of the record, but we might find that it wasn't necessary. We might find that if everyone read it, how long is it?
When are we gonna do
Well,
that?
why would we do that? I mean, typically we ask the applicant
okay,
to
I'm
give it
fine,
to us
I'm
more
fine.
than
I
at least
agree.
a day before the
I
meeting.
agree.
Okay,
And
I'm-
at the meeting is highly irregular.
I will provide the document that Arthur and I will do for the next meeting, and we will, live with the delay.
All right. So, could I get a motion to extend
Yeah.
till December 19th? We,
I'll make that motion.
thank you. The action deadline. This is the action deadline.
That's not the next meeting.
No, so it's
No.
the action deadlines.
To extend the matter.
So Mark made that motion. Who seconds it? Susan, did you second it?
Sure.
Okay, Susan seconds it. Any further discussion? No. All those in favor say aye.
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 Okay, so then the applicants sign that. Okay, so then we need a continuance to the what is the December date?
Who made that motion? I'm sorry.
Mark
I made the
and
motion.
Susan seconded it.
Is it the 6th?
The next meeting is December 13th.
Okay.
Regular ZBA.
Right. Okay, so can I get a motion to continue this matter to December 13th here?
I'll make that motion.
1 o'clock. Okay, Mark makes the motion. Who wants to second that one?
I'll second it.
Lisa seconds it. Any further discussion? No, all those in favor say aye.
Aye.
This is an aside, nothing to do with you. But in the paper today, it said something about the next 40B meeting being December 7th. I don't know if anybody cares about that, if we're skipping the next one, which
It should
wouldn't
say
break my
November
heart.
26th.
Yeah.
26th is
Just,
Tuesday.
I'm sure somebody's gonna call the paper, but,
Well, the reason for that is that's the meeting date we set at that meeting.
well,
Yeah.
whatever the
No,
reason.
we said the 5th, December 5th.
Or maybe it's the 5th, but I'm saying they skipped the
The
November meeting.
that we had already scheduled for that Tuesday, November 26th or 7th.
There is a meeting in late
I
November.
think I put an ad about the Searchlight Crossing in the paper.
Okay, we'll get to this later, but,
We had scheduled another
I
meeting.
believe there's a meeting scheduled for November 27th.
There it is,
There is.
and it's on the website. in all-
Right,
he
well, that's
said-
what I'm saying,
he
but in the
s-
newspaper, it said the next meeting is December something.
I
It was
don't
an
have that in
article,
paper this
though.
week, so I don't know who put that.
Do you mean
was
the-
an
No, it was in an article about the selectmen
Oh, so that's
appealing.
not me.
No, I'm not blaming you, I'm just saying somebody
National
might want,
Endangered Species Act.
They got it.
right, they got it
National
wrong.
Heritage.
That may be a select board related meeting, possible.
Okay, I think I read it correctly, and it said something about the zoning board. Anyway, somebody might want to call the newspaper and correct it.
I
I'm
think it's
sure
because
that,
the staff was, the paper was there and they heard us vote then
Yeah,
in the
yeah,
December meeting.
I
That's
shouldn't have
exa-
brought it up,
That's
obviously.
why it happened.
27th and then 5th, I got confused, okay, maybe.
Yeah, they didn't know about the 27th.
The newspaper got it wrong, is all I'm
Yeah.
saying.
We
The
didn't
point
know
is,
the 27th.
don't believe everything you read in the newspaper.
We don't, yeah.
It's fake news.
Fake news.
Fake news.
All right,
Okay, moving on.
Back to my client's matter. I
I thought we were
appreciate.
finished.
Yeah, I just wanted to thank the board for its high patience in this. I know it's been dawdling around for 6 months. Thank you, and longer. Thank you.
Thank you.
And as I said before, if it weren't for Mr. Cohen's efforts, we wouldn't be at this point right now, and we appreciate his involvement.
I was gonna say, it did sound heroic.
Arthur's my chief marketing agent. I really appreciate it.
I don't know.
Merciful.
About the emoluments?
Okay, moving on. 2318 Emma Ross, 50 Oak Avenue. There's a request to continue
That's
this
been continued for how long?
yet again to December
What's their action
13th.
deadline?
No, applicant's supposed to go before the select board at their November 28th real estate meeting.
Okay.
What does that have to, I don't remember that case. There's something about them going to the selectmen, but
It's
we said we
changing
don't
the
really
zoning,
care.
or there's a, it's a, they,
Zoning change.
Yeah,
Yeah.
but we.
No, it's not a zoning change. This is the one that had the
no build.
no-build
Yeah, we were still
area.
concerned
Right.
about that.
And we were clear, I believe, that just because the selectmen said one thing doesn't mean we might say something else. But anyway, we don't have to
What's
discuss
that
the
option? Oh, yeah,
simple.
December.
We just want to discuss whether or not we're willing to continue it to the 13th.
Well, I guess nobody's here, so.
And their action deadline's the 14th, so I'm okay with continuing it.
I'm okay.
Okay, I'll make that motion.
I'll second.
Okay, any further discussion? No. All those in favor say aye.
Aye.
Okay. Okay, I wasn't gonna sit on 4018. So you wanna take over?
Sure.
Thank you.
Okay, so, next application is 4018 Barbara Beinecke Spittler, 85 Millbrook Road. Arthur Reed representing?
Yes, Arthur Reed for the applicant, Barbara Beinecke Spittler. Mrs. Spittler is here with me, along with her husband, David Spittler. We were before this board in 2007. At that time, there had been a recent rezoning of their property on Millbrook Road, which had been in R2 zoning, the equivalent of what's R20 today. 20,000 square feet is minimum lot area, and 12.5% ground cover permissible. And that was rezoned as limited use general 2, which has minimum lot area of 80,000 square feet and 4% ground cover, a rather drastic change as far as the ground cover is concerned. This lot, in fact, is more than 80,000 square feet in area, so it is a conforming lot as far as the dimensions of the lot are concerned. However, the Spittlers had already developed plans for some alterations on their property back in 2007, and the zoning change, which they had no protection, left them in the lurch in terms of being able to proceed with those plans. And under the circumstances, we came before the ZBA with request for special permit relief for the alteration of the pre-existing non-conforming ground cover on the site, which was 4.7% at that point, to be able to go to 5.7%. Again, they would have had 12.5% under the zoning that was in effect before that zoning change. After some consideration, the case was reviewed by town council. It was continued a couple of times, and there was a question as to whether special permit relief was applicable. And town council ruled that it was, because it involved a single-family dwelling and accessory structures there too. If it were a commercial structure, it would have required a variance, and I think that applicability of the law has been pretty well established since then, that if you're in excess of any of your requirements, if you're in a pre-existing non-conforming situation with regard to single or two-family residential property, that you're able to increase it by special permit rather than by variance. In any event, that variance relief was granted. And the Spittlers did some, but not all, of the work that had been contemplated at that time. And they still have some ground cover that is available to them if the decision, which allowed them 5.7% ground cover, is applicable and can be used basically in any way that they want in order to get up to that 5.7%. We believe that that was the substance of the decision, but we thought that it would be appropriate to get that clarified so that in connection with work that they or any future owner of the property might want to do, that they would be able to get it up to the 5.7%, again, which is not a terribly high amount on a lot of that size, and is certainly consistent with other things in the neighborhood. Again, it having been rezoned after the neighborhood had already been, to a considerable extent developed. In any event, we are requesting that it be clarified that we have 5.7% ground cover maximum available, and we are also, that is, we can go up to that point. There are also several conditions attached to the decision. Back at that time, a neighbor across the street was concerned about maintaining screening along the road. So there was a condition included in there that required that the existing vegetation along Millbrook Road be maintained in order to protect the appearance from Millbrook Road and from across the street. We had agreed to that at the time, and we're not asking that that be removed. We think that it's entirely appropriate that that screening continue to be in existence. There was also a condition that there be no second dwelling on the property. What was contemplated at that time was not a second dwelling. And at that time, there was a deed restriction that was applicable to this property, which prohibited secondary dwellings. That deed restriction has now expired and has been expunged by the land court as a result of having expired. And since that deed restriction is out and that there would be no other particular reason why a second dwelling should not be permitted on the property, we're asking that the condition against second dwellings also be removed. So those are the two things we're asking for: clarifying that we're allowed to have up to 5.7% ground cover on the locus, and that there not be a specific prohibition against a secondary dwelling. And this would be in the context of modification of the existing special permit.
So Arthur, that 2007 application that I'm looking at, so you'd like to omit B and C?
Let's see.
B and D.
You got the copy of the decision out in front of me.
We said they're not going to touch D, so.
Oh,
There we go.
72.
Okay, specifically that B would be deleted. C would be confirmed that maximum ground cover upon the locus would be 5.7%. And actually A, tying it to specific plans that were approved at that time, would be removed so that we would be able to use the 5.7% for new plans. Obviously, we'd have to go to the HDC to get a new approval for anything that's done. We actually have had some plans that went to the HDC, didn't they? Yeah, a couple of years ago that they didn't follow through on, but we'd like to be able to simply be able to go to the 5.7% with plans to be approved by the HDC rather than tying it specifically to what was then referenced and not built. Then condition D would remain in effect.
So you're saying the proposed alterations were not performed in accordance with?
Not in full, no.
Can I ask about some of the others? There was something in the staff report about structures and the definition of a structure. Is there some question about the solar panel locations?
No, the bocce court. Solar panels are pre-existing non-conforming.
Okay, good, got it.
Because of the zone change, but the bocce court was, did you see that?
Yeah, I saw that.
It didn't.
Somehow it would never have occurred to me that a bocce court needed to maintain any particular setbacks,
I
but
did check with Marcus about that, and his interpretation is that it is considered a game court, which is considered a structure which must meet with setbacks. It was formerly shown as a sunken garden, and I suppose they just not realizing that it is. There are other people I know who have installed bocce courts, not thinking because it tends to be at grade.
Yeah.
It's a structure, but apparently the building department and the DEO do consider it a structure.
We consider it a structure?
What is
Isn't
it
it just
comprised of?
lawn? It's lawn or hardner or something?
Yeah, it's hard.
Dave, come on
Yeah,
over.
in a collar, or some retaining
Seems
collar?
crazy.
How is that a structure?
It's,
Game court.
It's a game.
I haven't looked at it, but
Why?
I'll
That's
let that-
ridiculous.
If you
Well, I
put
mean, I
two
thought-
pegs
I consider
and
it
you throw
hardscaping
horseshoes,
if
that's a
that.
game court?
Well,
No,
what
no,
isn't
it's
a game
affixed to
court?
the- it says-
What is a game?
it says fixed location
No,
on the ground.
no.
It has a fixed location on the ground. I can understand why you wouldn't want that 2.7 feet if there's, if it's from the neighbors.
I mean, game court is So ambiguous, what
Yeah.
game? But
Well,
Maybe a tennis
To me,
court, but bocce, no.
Well, it used to be
Well,
these
why do you call
elevated
it
platforms that people would put on property counted as ground cover back in the day. I remember Lyman Perry had one on his lot out in Pulpus, and they counted it as ground cover, and it was a structure because it was elevated.
well, regardless.
This is at grade.
Well, regardless,
But
it's
even if
it's
it's-
included in there. It may be ambiguous, but it is a game court. It is 2.7 feet from the property
Somebody would
line,
be
and
blessing that.
and Marcus thinks it's a structure, so it's going to be flagged anyway. So
And the
What-
deck, I'm assuming, was
What-
existing.
Dave,
because
what's,
it's
what's,
also within
what's
the
it
setback.
constructed of?
There's a border of wood, 6x6s, because you have to have,
Yeah, yeah.
you know,
Yeah, they're not that deep,
bounding.
Like a planter bed.
And then oyster shell is the surface that we can regrade for when we throw the balls.
Yeah, it contains the surface.
And it's roughly 60 feet by
Yep.
12 feet.
I mean, I understand that he's using it as a game court in that definition, but I wouldn't,
He hasn't seen it, I just showed him the plan, because my concern was I saw it as a sunken garden, and specifically called out on the plan as a bocce court.
right.
Now, whether or not that can be defined as a game court, he said, generally speaking, these are considered game courts. It might be something that he would take a look at, and he would say, this is a structure that can be moved, it's not a fixed structure. So I don't want to make that interpretation, I just wanted you to see it and figure out what the status is.
then do you want to continue until we figure that out
No.
I mean,
Is there a relief for it?
for the bocce court?
No, it's not, no, it was not, no.
It does sound that there's just a framing that could be, doesn't sound to me, and I'm not the CEO, like it is a fixed structure. It sounds like, I mean, the ones I
mean, I don't wanna
have
grant
like
relief.
gravel, not gravel, but
The garden bed.
Did you submit a
Yeah, but I
picture
don't
by
wanna
any
grant relief
chance?
for a game, for
Do we have a
something
picture
that's
of
a
it?
game
no, we don't, because we didn't anticipate the issue
Yeah.
until this came in the
Well,
staff
it-
report,
Yeah,
which
or
I
like
saw
game
last
court.
night.
Just in
Yes.
general, people would.
Yeah.
And that has
do
no
whatever they
border.
want.
So,
Well, it has the fence, but that's a game court because, I mean, really what it comes down to is the noise that it's generating within setback, I think. And also, a tennis court is fully fixed, I mean, that's.
And it has
board
fencing
foundation
and
as opposed to-
Totally different.
it's a totally different animal. But to
Was-
Susan's point is
was
how do you
this bocce
define
court
that?
part of the notice to the abutter? I mean, do they understand?
It was not, and I am not saying that it is necessarily a structure, I just wanted to bring it to your attention, because I did ask Marcus about it, I said, what is your interpretation of bocce courts?
I mean, we haven't asked for any relief with regard to it.
well, this brings about another question. You asked for relief on that first condition. Is that in the notice?
Notice
The
that-
substantially in the
The HDC approved
yeah.
components?
What we said was, we asked, our application specifically asked the decision be clarified to specifically state that the maximum ground cover upon the locus, which is allowed to be 5.7% under the provisions of the decision, may be utilized to increase the total ground cover upon the locus, which is now about 4.7% to 5.7%, regardless of the configuration of the structures and not specifically for the alterations covered by the special permit, not all of which were constructed.
I think that that's okay with condition A, because basically condition A would have established that 5.7
Yeah.
with those plans, so it's just subject to the new, you know, I mean, I don't have,
It's not subject to any architectural plans.
right,
It's-
at this point, they don't have HDC.
That's right.
So-
we
We're just
shouldn't even be
basically
considering.
confirming the previous relief and getting rid of that one condition.
But doesn't that relief expire if it's not
Right, that
used
was my
after
Was used.
2 or
Some-
3
some-
years?
Some work was done under it.
What was done?
What was done?
Was the garage constructed?
The workshop, it says. Is that the garage?
Workshop, and there was an addition to the kitchen area. So there were 3 permits. There's just 1 permit still out for a cabana structure.
Right.
So it's still considered live?
And, partial exercise, is enough to keep it permanently in existence.
Okay,
Right.
I just want to confirm that.
Yep.
Does the board have any other questions at this time?
The second dwelling, was that put in this decision because it was in the deed restriction, or was this maybe a separate?
I forget the exact circumstances of it, but it was an easy giveaway at the time because there was a deed restriction, frankly.
So
But
was
it was
this
given
something
away.
that
Yes. it was-
was done?
But the deed restriction is gone, and I don't really see that there's going to be any impact. It's a large lot. I don't see any
And have other lots in the neighborhood have exercised their right now to have a secondary dwelling? Is that correct?
Across the street, the last 5 years in the house, huge house on the top of the hill.
Could you speak in the?
Yeah.
There's no secondary dwelling there.
There's no.
No.
There's a separate building, but.
There's a second building, but it's not a secondary dwelling.
And what is the
I'm not
secondary
saying
dwelling
that they
you're
didn't want to
requesting?
exercise it, but
Is there
that's
something
not.
in mind?
I'm sorry?
This secondary, do you have a secondary dwelling plan here, or? is this
No,
just-
not at the
Okay.
present time. We're contemplating it. At least the possibility of it. We wanted to clean the whole thing up while we were at it and get the decision brought up to date in terms of what may happen.
There's nothing really about the second dwelling in here, only that they were thinking about converting the garage.
I mean, they're allowed to have, I looked at the decision from the land court.
It's allowed.
It's
yeah.
allowed, I just wanted to make sure there was no neighbor that was concerned about it, which is why.
No comments from any of the abutters?
Nope,
No.
doesn't look like it.
That would be my
Do you wanna go to the
concern,
public?
like Lisa.
And
Yeah,
ask
I
them
do,
if-
yeah.
My
have
concern,
anything to
similar
say?
to you, there was some other reason why this was,
Right,
second dwelling was prohibited, not just the deed restriction.
right.
I'm not sure why this would be put in.
There were, as I said, neighbors at the previous meeting,
Okay.
one in particular, who had a number of concerns, and that all got taken into consideration. And the major force on that was the condition that we keep, because we don't have a problem with it, namely keeping the vegetative screening.
I know, because I'm familiar with that road going to the landfill, because I live on the other end of Millbrook Road, that there has been a lot of natural clearing with respect to a lot of the vegetation along that road. May have been a lot closer to Nantucket Road by virtue of just dead pines and things like that. And I haven't seen any effort, and I'm not sure why there would be any at this point, of trying to mitigate the loss of all the vegetation along that road. There's been incredible loss along that road. So, yeah, I would say, since I wasn't at the last meeting, if the neighbors didn't have any issue with the fact that things are much more open than they were even 10 years ago, then that would be a consideration that we want to subject the decision to.
Mark, if you go from your house to the dump over that part of Millbrook Road, I hope your vehicle has good springs.
Absolutely. It's actually not a bad road these days.
Anyone in the public, in the audience, wish to speak about this one? Okay.
So how do we want to deal with the
The
bocce
bocce.
court?
That's,
It's not before us, really, is it?
no, it's not before you. I just want them to get it clarified with Marcus, so they don't have an issue.
Okay.
At the end of
But
the day.
even
we
if
can-
it's not before us, if we see on a plan that there's an air conditioning unit or something in the setback,
We can make
we
comment
can
on
make,
it.
we,
But it
You're
hasn't
not
been,
granting relief for the bocce court,
Right.
so if they don't get it, they'll have to figure out a way to get it, or they remove it.
or they move it.
when they get their building permit.
Right.
I mean, there's no construction going on there into the bocce court, in other words, so it's not.
I mean, we obviously will, separately from this, get straight with Marcus on that one way or another.
Oh, yeah.
And nor are we totally married to the concept that there absolutely positively has to be a bocce court in that location. If that becomes a problem, then we'd get rid of it. The question is, what does it consist of, and
Put
how would
sand
it
in
in
it,
fact
make
be?
it a sandbox, and that's not a game
Yeah.
court anymore.
Well, that's right, and as noted, it had been a sunken garden, as previously described, which
Your
got
raised
converted
terrace.
into a bocce court. Well, back and forth, what can I say?
Yeah, I think it could be just that he'll take a look at it and say, this does not count as a structure.
I would hope so.
And if he does, they'll move it.
Yeah.
Or do something with it. Fill it full of
Make
soil
yourself
and
a
make a garden.
Okay. Does anyone want to make a motion on this one?
I'll make a motion to approve. So how would we put this together, Eleanor? Would we refer to the old decision and 5.7 for A, I guess, and then take out, what do we say, C?
Strike, I think we're gonna strike condition A and condition B.
Right.
Okay.
And confirm,
C and D
just
would
C
stay,
and D.
right?
So it's a modification of the 2007 decision
Correct.
To delete.
that clarifies the relief
You're right.
to do the alterations, increase the ground cover for, then existing. It's now 4.7 and they want to be able to go up to 5.7.
And then without further, no further expansion without further relief.
Right.
Mm-hmm.
then the
And strike
remainder-
the second dwelling component.
right,
Yeah.
The remainder of the relief shall remain in full force and effect.
Anyone to second?
I'll second.
All those in favor?
Aye.
Aye.
Thank you very much.
Thank you.
Thanks.
Do you want to get those guys back in here? If they want to.
You guys go get a sandwich or something? Or? It was magic. Okay.
So there we are.
Good to go.
4118,
got it?
William F. Hunter trustee, 281 Hummock Pond nominee trust for the applicant.
Mr. Chairman, Kevin Dale, representing the applicant. Bill Hunter, trustee of the 281 Hummock Pond Nominee Trust. This is an application for a swimming pool special permit under Section 139-2A of the bylaw. Property is located in the Village Residential District. The lot has an area of approximately 132,000 square feet.
Oh, here. You don't have
The
to
minimum
take it.
lot size in this district is 20,000 square feet, so the lot is significantly bigger than the minimum lot size. Secondly, the proposed swimming pool will be at its closest point, pool and equipment, more than 34 feet from sideline or rear or front setback boundary lines. Thus, property meets both criteria for special permit. The lot's bigger than 20,000 square feet. Setbacks are more than 20 feet, and would ask that the board grant the special permit. But I've had an opportunity to review this board's decisions in the so-called Nantucket swimming pool cases that took up a fair amount of the board's time. And I wanted to add some conditions that the applicant will live with if the board wants to impose them. First, for the record, the swimming pool and the cabanas have been approved by the Historic District Commission, Certificate of Appropriateness number 70200. The submitted plans show that there are two cabanas that will screen the pool from the private easement running north of the property. There'll also be additional vegetative screening on either side of the cabanas and a vegetated berm along this access easement that runs from Mothball Way down to the Sternlick property at the end. The pool mechanicals will be housed in a small wart on the north side of the east cabana, as shown on the site plan. The pool lights will comply with Chapter 102 of the Town Code with respect to appropriate lighting. And finally, the applicant will engage a professional company to fill the pool as needed. The pool will not be chemically treated between November 1 and May 1. Any chemical treatment of the pool will stop at least 3 weeks before the pool is drained. And if this is not feasible, the applicant will engage a professional company to put the water from the pool in a tanker and take it to the wastewater treatment plant. So these conditions mirror the conditions you imposed in the Nantucket cases. And even though I think this is quite different from the Nantucket situation, I understand the concern that this board has for swimming pools. So I'd ask that you grant a special permit.
Thank you. Kevin, you mentioned a lot of landscaping. Is there a landscaping plan attached? I didn't see it.
No, I don't see
The only plan we have is a site plan.
All right, I think in the past, I didn't sit on one. Only sat on one of them, but I believe we required a landscape plan that showed the things that the applicant described, which you just described, but, well, here it is. At the November 17th meeting, Attorney Brush presented a more detailed landscaping plan that had been approved by the HDC, et cetera, et cetera, et cetera. So I don't know, I didn't sit on Halleck, but did we do it on that one?
Thought we had
Both of
that.
them had.
Lighting.
Alec had a
And a lighting
comprehensive plan.
plan, yeah.
Yeah.
Yeah, and a lighting, a lighting plan. So, I think we should stay consistent and ask you to submit that material as well.
Just one point. There's a clear material and significant difference between this application and the Nantucket applications. The closest house to the property line here is 167 feet away. This lot is 4 or 5 times larger than the Nantucket lots. And the cabanas will shield the pool from any view. So fundamentally, this is different from denser, smaller lots that want swimming pools. Having
Well-
said that, if the board, in its wisdom, wants a landscaping plan, let's continue the hearing until the 13th, and I'll get you a plan.
Yeah, I mean, just in reference to your remarks about distance and whatnot, as I remember, the Nantucket issue was a lot of
One
the
of them.
opposition was across the open swale, and it was a heck of a lot further away than 173 feet.
So one of the
So,
applications, that's definitely right. The one that was on, I can't remember the name of that restaurant.
Millie's?
Yeah.
Yeah.
Between Baltimore
Mr.
and.
Chairman, that's a point well taken, but unlike the Nantucket cases, there's no opposition to this application.
I was just gonna ask. if
having
you were
said
gonna
that, I
answer
think
some opposition.
for whatever reason, whoever came up with this idea that we were this even requires a special permit, we might as well be consistent in our
I agree.
requests. So,
Although I think that the applicant should be given credit for the fact that they have a very thorough abutters list. 4 of those abutters properties fell into the ocean more than 20 years ago.
And Mr. Chairman, I'd remind you that Ralph Waldo Emerson said that consistency is the hobgoblin of little minds.
amen, brother. But I think we're just gonna. I feel like my mind is tiny.
I'm happy to submit.
So submit them. I don't think anybody has any problem with the pool itself, but let's keep it consistent.
Is there anybody
It
in the
should be very
audience?
easy because of
What's
the.
that?
Just-
Anybody in the audience want to talk about this
There should
one?
be very little landscaping that needs to be
No.
considered.
No, he offered up what was a berms and
Yeah.
15 or 100-foot
screening.
evergreens, and it's, I don't know what else he said,
Oh,
but
redwoods and.
Generous
sycamores.
offer, I might add.
heroic. I'm only disappointed that Arthur isn't here telling us how wonderful you are too.
Brother.
Well, the
Okay.
conveyancing bar tends to stick together, as you know, Mr. Chair.
I do know. All right, we are on the tape, so I'm sure. Let's move on. So we're gonna continuance till December 13th, right here.
Sure.
So moved.
All righty. Jim moved it. Lisa, did you second
Second,
it?
I'll second it.
Okay. Any further discussion? No. All those in favor say aye. Aye.
Aye.
Thank you.
Thank you.
Okay.
Screening.
Plan, screen.
Well,
4218, Deborah Bard Rogers and William H. Rogers. That's not right. That's what it says.
Roberts.
I know it's Roberts, but
Renotice.
16 Greenleaf Road. That's not a renotice issue. For the applicant.
Good afternoon, Mr. Chairman. For the applicant, attorney John Brescher, representing the property owners Deborah Rogers and William H. Roberts, the owners of 16 Greenleaf Road in Nantucket. What we have before you today is a variance request pursuant to zoning bylaws section 139.32 from the intensity regulations of section 139.16 in order to validate the siting of a structure which is approximately 14.1 feet from the rear yard lot line in the district that requires a 15-foot setback. The fact pattern on this one is a little nuanced and frankly unique. There's a single-family dwelling and a secondary dwelling on the locus. The locus actually has the benefit of variance relief from circa 1993 because back in 1978, a subdivision plan was filed and there was a surveying error. And effectively, all the lots on Greenleaf were undersized. And so in 1993, the applicant went to the Board of Appeals to receive variance relief in order to have the lot validated as separately marketable and buildable, which the Board of Appeals did so, and there's a copy of the decision in your packets. In doing so, the applicant and the property now has variance relief to render it a separately marketable and buildable lot, which in turn does not give it the benefit of being pre-existing non-conforming. In Marcus's eyes, his term of art for this is that it's a non-compliant lot. However, this was unbeknownst to effectively everyone until my clients applied for a building permit. They looked at the plan from 2000, which mentioned record, and therefore assumed it to be lot of record. They actually had conversation with the architect, surveyor, and with the building department about what the rear yard setback would be, as they were going to site a secondary dwelling. And everyone said, okay, well, you're a lot of record, so your rear yard setback is 10 feet. All well and good. They apply for the building permit. They list in there that, okay, it's going to be 11 feet from the lot line. They actually constructed, so it's 14.1 feet. They receive, all the work is done. They receive all their sign-offs. It goes in front of Marcus's desk for zoning review, and he says, hey, wait a second. You have a variance on this property. This isn't a lot of record. Your setback is 15 feet. And so they are off by 0.9 feet as a result. This is as honest as a mistake as it gets. They were not trying to game the system by any way. Had they received notice from the building department, or even when they applied on their building permit application, if there's any indication that it was to be 15 feet, they would have cited the second dwelling at 16, 17, 18 feet to give themselves some wiggle room. You can see as much on the site plan prepared by Paul Santos. There was ample room to site the secondary dwelling. However, through a series of honest mistakes and sort of not catching it at the building department, everyone had assumed that it was a lot of record and therefore a 10-foot setback until it received some closer scrutiny in trying to get a CO. And it was determined that it is in fact a 15-foot setback because it is not in fact a lot of record because of the variance.
Yeah.
So with that set of circumstances before us, we have a letter in the file from the most impacted direct abutter, Mr. Wayne, who indicates that he is fine with it. My client is here and is happy to discuss if you have any other questions about this. He has received basically the blessing of all the impacted abutters that it doesn't matter to them. And I think that in this instance, variance relief is appropriate because this is a unique situation because we're not finding lots similar to this whereby the surveyor messed up a land court plan and the lots had to be validated via a variance, and then nobody at the building department caught it on the building permit application, went through however many rounds of review up until getting a CO. And I think that's how we can hang our hat on variance relief for this. We can't do an unintentional setback intrusion. And so I think that due to the uniqueness of this circumstance, that variance relief is appropriate. As I mentioned, my client is here if you have any questions, but we hope that you can see your way to variance relief for this.
Thank you. How do we feel about this? Any questions?
It's just the deck that's over, right?
Yeah, we don't have any plans per se.
Well, there's a site plan.
No, we have the site plan, but it's is it just a step?
It's just a deck. No, it's a deck edge. It looks like there might be AC units, but they look like they're
Okay, then the
outside.
steps are going the other way?
I don't see steps are here, right?
Is that, are those, all I'm saying is we don't have the plan, so it's difficult to see.
Yeah.
Encroaching.
It's just the top of the stairs
Yeah,
that's
the
in
landing.
The
violation
landing.
by 11 inches. The stairs that go to the deck. The HVAC unit is not in violation, it's just the
Yeah, it's hard to tell what these are.
the corner part, maybe about, I don't know exactly, but 5 or 6 feet. Oh, William Roberts.
When we looked on the building permit application, although I think that the side might be wrong, they do have left at 11 feet. So they clearly thought they were a lot of record.
Yeah, I mean, given the fact that the town is a participant in this, as well as the fact that the closest abutter and probably the only butter that this could affect, if it affects anyone, has written a letter, I think it's definitely a candidate for a variance.
So, John, if this was a non-conforming lot, this would probably be allowed, you're saying, so, which is,
As opposed to
That's correct. If it were considered a pre-existing non-conforming lot of record, then the Lug 2 setback requirements are 10 feet for the rear yard. But because it isn't, it's a non-compliant lot, it reverts to the standard 15-foot setback.
I agree with everything that's been said other than one thing. Just because you put it on the application, in this case, it doesn't matter, but you put it on the application, oh, we're going to be 11 feet. And if that's in violation, the building department doesn't pick up on it. That doesn't mean
Well, all I'm
it's
saying is
okay.
that clearly they thought
Yeah,
that
I
the
agree.
setback was 10 feet here.
Yeah, everyone did.
Yeah.
Well, particularly because they are a undersized lot, non-conforming lot, so.
Yeah, I don't have a problem with it. Does anybody else in the audience want to talk about this?
And the neighbor wrote a letter and said she was fine, so. Should I make a motion to,
Do we just want to validate the
Yeah.
stoop intrusion as opposed to changing the?
yes.
Yeah,
Exactly.
absolutely.
And do we have to do anything special because it's the variance, or do we have to explain it differently?
Well, we specifically want to find that owing to circumstances related to the soil conditions, shape, or topography of such land or structures,
Or hardship.
but not generally affecting the zoning district in which it is located, which, you could say that this lot, because it was,
Undersized.
had the zoning issues, is different. A literal enforcement of the provisions of this chapter would involve substantial hardship, financial or otherwise, petitioner or appellant, so. Okay,
Okay.
Hang our hats on.
so is that a motion? Did you make a motion?
I made a motion.
To grant the relief as requested.
who's voting?
Excuse me?
Who's voting?
Why don't the 5 regular members vote?
Do you need a second?
Yes. Michael seconds it. Any further discussion? No, all those in favor say aye.
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 Thank you.
Thank you very much.
Thank you.
Alrighty.
The next one I am representing because this particular applicant was unable to be here, and the person who was supposed to represent for him declined later in the game. So if you don't mind, I will represent this. That's okay?
Should we do it last?
I would think that'd be somewhat irregular.
It is somewhat irregular. This is an elderly gentleman who left the island, and he submitted the application in time for the November hearing and didn't understand that he needed to be here and have somebody.
Is it okay with the ethics?
I'm going to say that would be highly irregular.
He doesn't have a problem continuing it. I just wanted to put it up.
Let's
How does
get
that-
a
I would
read
say
from
this,
town council.
I
Well-
would say this, that
You don't need to, I just asked that.
I've seen applications, I wouldn't say you're representing the applicant.
Stating the facts.
You're,
Correct,
you're available to answer any questions where you have the answer,
correct.
Which were-
That's a much better way of putting it.
which were given to you by the applicant.
Correct.
I mean, it's
Yeah,
up to
I have a
everyone.
problem if Eleanor is going to advocate for
Right.
the
Yes.
application.
No, that-
So I would feel,
I misrepresented myself by saying I'll represent. I think much better to phrase it the way you said it, Michael, which is that I will state the facts as they were given.
and again, keeping with the small, consistency is the, whatever, sign of a small mind. I would like to stay, normally an application is not presented even by staff member. I
Well, I
mean,
did ask my supervisors, and I was told that this does happen on occasion.
I would say that
We have no pro bono
if
attorneys in here today.
I'd consider this to be tantamount to one of the applications where the applicant shows up without counsel, without anyone that knows anything. Application's called, is the applicant here? Yes, he's here. And he doesn't say anything. He's just here and can answer questions sometimes. So it's up to the board. I don't care, but
I'm entirely comfortable with whatever you decide.
the fact that Eleanor is going to answer questions that she may have the answer to or doesn't have the answer
I mean,
to.
it seems pretty straightforward, though.
Right.
You could
Basically,
also
the
just
zoning-
read the.
Oh,
You
okay.
could just read the.
zoning
To rescind and vacate a variance.
Yeah, it's
I don't
pretty
have to say
simple.
anything.
Because the zoning changed.
Yeah,
Yeah.
you can open it and we can
I mean,
discuss it.
notwithstanding your representation,
I don't,
it's not a requirement, right, that people
No,
No.
no.
it's
be
preferred.
here for
It is
the hearing.
preferred.
no.
Well, it
This
just
is
is preferred
pretty
for them
simple.
in case if there's a question that can't be answered, it gets
Yeah.
continued.
well, I think it's a little awkward if you're, is the chairman supposed to present
No,
all
No, we
the
all have
case?
I guess
Or we all just say, we read it, let's vote on it?
Yeah, I mean, it's our responsibility to read the application
Right.
and know what
Well,
we're talking about.
I agree 100%.
Let's just
but-
try to move forward with it.
Yeah, I mean, if, I don't think this board is in the business of telling applicants that they really need an attorney. Somebody came
this is
up to me
straightforward.
outside of
zoning
this
change.
meeting and said,
seems like a
do I
non-event."
need an attorney? I would say, I recommend it.
Yeah.
Well,
Well, I'm not even saying an
Yeah.
attorney. I think
Yeah, but I-
somebody
Yeah.
should be here. But
Well,
what if we were to, again, maybe not in this case, but put some, how can we even condition something without,
well.
well, I
that's
suppose
their-
that's,
That's their.
I,
Yeah, that's
There's
a
no
risk.
need to. Zoning is conditioned, this whole thing.
no, I'm not talking
Change in zoning
specifically
here
about
is
this.
conditioned.
but How do
So-
you feel?
Rescinding of
I
the
feel like
variance.
if this was something, and we've done this before, where we feel that when someone isn't here and we feel like they should be, we've continued it, or we waited till the end of the meeting for someone to show up, but if it's pretty straightforward,
Eleanor, do you know
I
if
think
the
it's
applicant would
okay.
prefer to be
Uh-huh.
here?
He would not.
He would not prefer to be
He
here.
would not prefer.
Is he gone for the winter?
Yes.
I think we should
Yeah, it's-
move forward with it and see
Yeah,
what
I-
happens.
I think
I mean, I think
we do
into-
case by case, and this thing doesn't look that hard, so.
yeah, I think in discussion,
And
if
he
we
lives
came
with the
up with
decision.
bigger issues, then we would continue it, and
Exactly.
the applicant would have to find someone
To represent him.
or he'd have to write a letter or some way to
Yeah.
communicate with us.
So can I make a motion? We don't need to make a motion to go forward.
No.
Just go for it.
Okay.
All right. Did I?
Just want to, is it question time?
No.
Okay.
Go ahead.
No, it's nap time.
Let's take a 5-minute break. All right, let me at least call
Please.
the application. 4318 Edward C. Fawcett, 52 Pochick Avenue, for the applicant. No one. Okay. So there we have it. Now, you have a question?
Well,
And who are you addressing it to?
I guess the Eleanor, who may have the answer.
Okay, perfect.
It's simply vacating the variance, nothing else.
Correct.
Okay. So
And and
zoning's been changed.
right.
So the variance was issued at a time when it was lug 2. and now it's lug 1, and they are compliant.
Please identify yourself for the tape.
John Brescher.
Eleanor Antonietti, zoning administrator.
Thank you. Go ahead. Did you want to say something?
No, I just do want to reiterate that Mr. O'Mara and Ms. Patricelli are correct, that this is a vacating or rescinding of a prior variance decision that was granted for relief that is no longer needed by virtue of a zoning change. The applicant wants the ability to, at some point in time, construct a second dwelling, which he cannot do simply because there's a condition in that variance restricting it to no secondary dwellings.
Okay.
He also stated in the addendum that he has no immediate plans of building a secondary dwelling, but would like the option.
And the planning board will make that decision
Absolutely.
at the time that the second dwelling's applied for.
Correct. And as I believe you may have read in the staff report, the lot will eventually be enlarged by 12,000 square feet through the yard sale program conveyance that is undergoing land court registration.
Okay. Was this the one that I saw Mr. O'Mara's name in '89? Yes, it was.
You really like bringing that one up, don't you?
He was 19 at the time.
Yeah, here.
18.
I'm going to see a picture of that.
All righty. So, are we good with it? We're good with the facts such as they are? And the public, anybody want to speak about this one? No. Okay. So somebody want to make a motion?
I'll make a motion to request to rescind and vacate the variance granted in 1989.
Okay. So basically to grant the relief as requested. Anybody want to second that?
Second.
Why don't we go with the 5 regular members again? Any further discussion? No. All those in favor say aye.
Aye.
Michael, you seconded?
Yes.
Thank you. Okay.
That guy is good.
None was good. It's the quickest one. 4418 Scott M. Rankin and Jessica L. Rankin, 10 Washington Avenue, for the applicant.
Hello, Louis Kelsey, representing the Rankins. We're asking to be able to add a second story to the existing building that's there. It was originally built in 1967, and the zoning has changed around that area since then.
Okay, and you all set?
Yep.
The issue is you're going up in the setback.
Correct.
Okay. Any questions at this point from the board? Pretty clear on what's...
I don't know, it's just yeah, I'll ask it as a question.
Go ahead.
I noticed that NERDA threw a letter in today.
I saw that.
NERDA's-
And I'm just curious, is there anything that you've got planned to take away their concern?
There's plenty of room for parking on the lot itself for us. I have a small crew, unlike the C Street job that went on. I don't have 20 guys, I have 2 guys.
Okay.
So there's going to be a small amount of vehicles there working. And we should be done by May,
May, okay.
if all goes well tonight.
Thank you.
I think the bus runs year-round out there, correct?
I don't
No,
know about that,
okay.
no.
So, would you like to speak versus just rely on your letter, please?
Paula Leary, NRTA Administrator. I think the questions asked answer my questions. If it's going to be done by May, it won't pose an issue for the Transit Authority and the Nantucket route. And certainly if it goes past that and there's not a ton of, vans and oversized vehicles that are blocking that pathway, we should be okay.
Okay.
Thank you.
So if nothing else, we could condition it to, I don't even think we can condition where you
No.
park.
I mean, the last thing that's gonna happen there is a landscaping, so they're gonna have to move off
Right.
the property, obviously, so. But I think as long as the applicant and the applicant's agent try to cooperate, then make every effort to cooperate, then I'm happy.
Maybe a accessible point of contact is what you're getting at?
Yeah.
No.
That's,
Okay, where do,
is there anyone in the audience?
we'll just, oh,
Yeah.
wondered why you were here. Feel free. Okay, we're gonna hear from the audience.
I have 3 sets of pictures. 4 pictures are
Just one at a time.
Patricia Stolte. I own property at 19 Baltimore Street.
Okay,
This 10 Washington Avenue is on the corner of Baltimore,
yep.
and diagonally across from this property at 10 Washington Street is 1 Washington, which is also going to be under renovation. So I'm going to pass these pictures to you.
Please.
So you're at the very end in the water.
I am.
Okay.
Yeah, okay, I see, yes. This is the house in question?
Yeah. And the bulkhead is facing.
Last summer, the Heather's Heaven project on C Street had, at times, 14 vehicles parked along Washington Avenue from E Street to A Street, causing, the only passage was pretty much on people's lawns by vehicles that wanted to go buy these cars. And the NRTA bus, the Wave, had to be rerouted onto Baltimore Street Extension, which is in one of the pictures there. That extension of Baltimore, the little crossover between Nantucket Road and Washington Avenue, was cited on a plan to have a yard sale taking it to the middle of the road to be closed off by the abutters. So that would not allow for the Wave to pass that way. It would also not allow for a fire truck or ambulance, propane, oil, anything else we need at the bottom of Baltimore on the creek to be delivered. My concern is not just the traffic when there is a project on Washington Avenue, but the encroachment on Washington by the properties abutting it. We've had, I don't know if you're familiar with the old Thompson house that was renovated 3 years ago, but they put fence right up along the road so that you can't even step off if you're walking the dog and the car's coming by at night. Something to be taken into consideration.
Question for you. You said that the yard sale taking was going to diminish the traveled area of the roadway?
Of the Baltimore Street crossover that's between Nantucket Road and Washington.
Just that little section. Well, things like the fence, that should be enforceable. That, I mean, the roadway layout, not the path.
Right.
Just looking at the GIS and at your pictures, looks much wider than the roadway itself. The layout is much wider, and you can only legally put your fence up to your property line. So if someone has illegally put their fence up to the path, the traveled way, unfortunately, that's not our purview, but I'm just saying you should be able to speak to somebody.
Everyone that I've talked to has given me the same answer.
Well, I find that hard to, I find it hard to believe that the
Not
police.
us, there's somebody else that you have to approach for it. I mean, even the aprons that are being installed for the driveways are technically on Washington Avenue.
No, I think the,
Yeah.
It's not
the
unusual.
DPW is who you should talk to.
The DPW,
Because
yeah.
I know that if there's vegetation that's blocking people's
Exactly.
Oh, yeah, they'll
visible
come to
line of
task.
sight when you're driving, they'll write you a letter.
They'll write you a letter or come by and say, we're gonna cut your hedge down.
Right. If you
fix
don't do it yourself.
I mean, the apron, for what, and I hear what you're saying, but it is not atypical that the apron goes to the traveled way. There'd be no point in having an apron that started at your property line outward, into your line and had dirt, I don't think.
No,
No.
you're right.
But
I
it's,
think the apron is allowed in the traveled way, in the roadway layout.
it's really fencing and large vegetation.
And big rocks and
No, none of that's
grass
kosher.
plantings and all of that.
I mean, and or if you, because I've seen this in my neighborhood, some people tend, the
To
shoulder
encroach. Why don't
and
we
are
tell it
very,
like it is?
very protective of it. If you make the egregious error of parking on it during Daffodil Day or something, you know, people get angry, but it's really within your rights to park there.
Yeah. We had
Um,
issues with sprinkler heads.
Yeah, but
Sure.
if you put your sprinkler head in there and it
It's
gets
their problem.
damaged, that's, you really shouldn't be able to do it, but
Yeah.
I don't know if any of that
So
answers
the-
your question,
The
but
travel way and the road layout may not be the same.
Right.
And so you just need to get back into the records, either through the DPW or Roads and Rights of Way, find out what it is, and if you think there's an issue, unfortunately, you would have to have somebody survey that issue. And
I would
or
have
the
to.
DPW would.
well, isn't there a
It's a-
Mattocket
it's-
Homeowners Association
Yeah.
that
Do you wanna
would?
just see
and
what
that,
we're
that
talking
may
about?
be an avenue.
No, I understand what you're talking about. What I don't understand is that it doesn't matter who I've talked to. It's somebody else's department who's supposed to take care of it. And I don't know how you go out to Mattocket where C Street goes the length of Washington and runs into Mattocket Road. All summer long, you have Millie's people that have been parking there, so they've had to hire detail. The same thing's gone on when there's been construction in this section, that the wave can't drive down there. You could get run over if you're trying to walk because there's cars parked, there's no room, because everybody's got plantings or berms, and it looks like they own the property right to the road, and so it's not passable. It's a problem. And I'm asking for the problem somewhere to be addressed before I can't get a fire truck down my road because we got a telephone pole, we've got right across the street, there's a fire hydrant, we've got another telephone pole. And if people think they own to right up where the blacktop is and they put stuff there, it doesn't matter if you ask somebody to come cut down a hedge, you still can't make a turn with a vehicle.
Yeah, these are all legitimate concerns. What we're speaking about is specifically this application. We can certainly condition the relief if it's granted to say you. I mean, I don't even think we can condition the parking. I don't think we can say you cannot park on the road layout. Can we?
I don't
Did
think
we
we
do that in
can.
Did we do that in
But I
Scottsdale with
think
the
we can
public
say that
domain?
just because there's neighbor concern that the applicant will not put a fence up or anything like that outside of the property line.
Well, without question. I mean, we can reiterate that it's you'd be non-compliant if you did, but I'm just I'm wondering if we can do anything about the construction parking. The other people, Mattocket Millies and fishermen and everything else, I mean, that's not us by any means. I mean, it's really only specific to this
So the proposal that's in front of you, if they're not done by when the NRTA starts their route into Mattocket, can there be a condition that they can't park half on the blacktop and half on the dirt because you can't pass another vehicle?
This is specifically on Washington?
Yes.
If you look at the plot plan, it shows that our driveway is in the center of Washington Street, on the side that it goes to Washington Street. There's a garage there as well. So there's plenty of parking for our
Two vehicles.
on. And we can actually go in too because we're going to be under construction. Like you said, the last thing we're going to do is landscaping, so we can park on the property and not on the street. And at that point, we should just be down to painters, so.
Is the vegetation in front of on the Washington Avenue side of your property? It's a 50-foot wide, by the way, road layout. That's huge.
It is huge.
Lawn all the way from the house to Washington
So
Street.
why would you ever, I mean, I think just to be a good neighbor, you would park on your own grass.
Exactly.
But we can certainly put it in the conditions so that you could call Marcus and have him go out there and enforce it to the extent that he can.
Good luck.
I didn't say
I
it, but
think this is more of an issue where, you try to get no parking signs or things like that, but it's, not for this specific property, but for these other areas, but it's outside what we can do for this application.
Okay.
I mean, in Baltimore, as it pertains to this particular application, it's 40 feet wide on that side. I mean, there's a huge amount of area where you could park a vehicle as long as it's, the applicant isn't saying to his client, we won't park on your grass. If they consider it their grass, it's not their grass.
Is the
So,
phone pole roughly on the corner of the lot?
That road is, it goes down that west side.
Right.
And it's all vegetational on there anyways. There's no parking. It's one car in, one car out.
And they put in the new septic in the back, so they can't park
Septic's
back
already
there.
been done.
you can't what?
They couldn't park behind the house where it was clear because they put in a new septic.
But in front of the garage and the driveway.
I mean, the vegetation's not a good thing out there from a parking standpoint because you can't get off the road to park.
Right.
So I see your concern and it's legitimate, but I would think that the Nantucket Homeowners Association would get together and clear those, but probably nobody wants to cut down the
What is
trees.
this? Is this fence? This dotted line here?
I think it's fence, yeah.
No,
that's the road.
That's
the traveled road.
The dotted? No.
Are you talking on Nantucket Road?
No, but I'm just saying here.
This is C Street.
No, I know.
Yeah, I know.
I know. But
I think it's what the road's supposed to be.
It's hard to tell.
The white is the pavement, is that right? And
The white is definitely.
Yeah, the GIS is the GIS.
Right.
We can't, but that might be a fence.
That might be a fence.
That somebody's put illegally onto. Yeah, I would say that's a fence, absolutely.
Yeah.
Somebody's on C Street, if the GIS is correct, which inevitably it's
I think they're
not.
taken completely straight ahead oftentimes, so that fence is probably on the street. It's not in the middle of the road.
And there's also public parking down closer to the beach. And if it was a problem, people can park down there and then walk back. It's not that far. For my guys.
There's very few people in Nantucket until after the end of May anyway.
What's that?
I said there's few people in Nantucket until the end of May anyway, so if they're done by then, it won't be a problem. But it has been a
Good
problem.
ones stay year-round, I guess.
Thanks.
All right.
Colleen Weldon, 14 Baltimore Street, and I am a year-round Nantucket person. We do live right down on the creek throughout the year. I took the first 4 pictures that I handed, or that she handed to you this morning. My biggest concern is those telephone poles or electricity poles. If the applicant is moving to the west and or up, those poles are going to need to get moved, and I assume that they will be moved closer to Baltimore Street. Then in the circumstance, which I know it's not before the board right now, but you do look at the big picture, if Mr. Turner, that is catty corner, is successful in closing that piece of Baltimore Street between Nantucket Road and Washington Street, we're going to need to completely blow out the opening to Baltimore Street in order to get a fire truck, a fuel truck, our boats, and any large vehicle down Baltimore Street because we'll need that turn radius. So if those poles move closer to Baltimore Street, it could make it so that we can't get into our property with those larger vehicles. And that's a huge concern.
Totally legitimate concern. I don't, and it may be pertinent to this particular application, but it's an interesting question that I don't know the answer. If the line should not be on their property
I
as
think
it
it's off the
crosses.
property.
So if they go up, they're fine.
Yeah, they're
Right,
going
not
up.
look how
moving. The
close they
building
are
is-
to the building.
Yeah, but they're
I
not moving
understand
the
that.
building.
The building's not moving.
They're just going up.
But it's going up.
Yeah, but they're not going to be
Should
in
not be an
the
issue.
line of the lines. If you look at the first photo,
Yeah.
they can
Yeah.
go up without hitting the phone poles.
I mean, it's going to be,
tight,
they may
right.
be looking at wire, but.
And if they ever decided to widen the road, they'd be a lot closer to the road, obviously.
Right.
It looks like the pole is on the corner, which of the,
I think
of
the
the
pole
lot,
is on the line,
which is
on the edge of the right of way.
yeah.
And the pole is that's an easement with National Grid, so they would have to look at
Verizon,
that.
whoever owns the pole.
it is, yeah.
And we're not trying to pass the buck, but these are things that. Are you proposing to move the poles?
We do not plan on moving the pole. We don't think that it's necessary, and we'll cover the wires
Right.
while we do it.
Protect
We'll
them.
have them come out to cover the wires to make sure that nothing happens to them,
Right.
and nothing happens to us while we're working, more importantly, so.
I get it.
Okay. I mean, that was our biggest concern, is that little by little, we could lose access to our house with larger vehicles, so we want to make sure that any decisions made by any of the boards take that into consideration.
Yeah, totally legitimate. But I think that maybe you want to, I mean, if you're really concerned about it, you would get together with the Nantucket Homeowners Association or whomever, or the DPW, and clear out all this vegetation.
It's been my experience with some of these boards or associations that unless something directly affects one of the higher ranking people in that board, they don't necessarily give you the attention that you need in order to make something like this happen. That's been my experience.
It's probably a fair characterization, but again, maybe the DPW is who you want to speak to. I mean, I don't know who can. I don't know if the road's private. You know, there's all
Right,
sorts
there's
of
lots of things.
things that. So you own to the
You own to the center of the
own
road.
to the center line, technically.
It's in a butter's way.
Okay. Again, unfortunately, we're not. I'm not trying to kick the can down the road, but these things are not within our purview. Other than to say to Lewis and his client,
Don't develop the roadway.
or don't park on Baltimore, but well, Washington, there's enough room to park on the grass.
You can park on the grass and not be on the road. There are no sprinklers. It's old school.
I think it's, a lot of it's educating the subcontractors out there where they can park and where they can't park. We
Yeah, it's-
ran into something this past year in our subdivision where we contacted the homeowner, we contacted the contractor, we put up stakes and said, please just honor our needs to get down this road. And they did. If you don't, they won't. They'll just park helter-skelter, do whatever they need to do because it's convenient for them. So you got to do it from the get-go. You can't do it in the middle of the project and expect that people are going to pay attention.
I addressed this with the people working at Heather's Project on C Street at the very beginning because we were one of the few people there year-round.
Can I interrupt you just for a second? Because this is being taped, et cetera, you should talk at the mic. Please.
I did address that, what you said about talking to the contractor at the beginning, and he seems a lot more amenable to working with us. But I did that with the C Street project, and the next night when I came home, my mailbox was on the ground. So that's kind of where we were at.
Yeah.
I had nothing to do with it. I think you're blaming me.
That's terrible.
The applicant's agents already agreed to give Miss Leary his phone number. Perhaps he'd be willing to give it to these young ladies as well.
Absolutely.
Have it.
Good.
You know, again, some of it's, as Mark said, you have to be a good neighbor, and if you're a creep, you're a creep. We can't, unfortunately, we can't control that. There are a lot of them out there. No. So.
Well, thank you for your time.
Thank you. So, what do we think about this house going up in the setback, which is the crux of the issue for us? Thank you. Are we okay with it?
No opposition from any abutters relative to the expansion upwards, just concerns about traffic and parking and construction protocol.
Yeah.
I don't see where it's any different from a lot of the Nantucket projects that have been before us in the past.
I want to just confirm one thing. Is the deck going to be over, the new deck that you're building is going to be over the setback? Is that
No,
correct?
It's going to be inside of the building envelope. It's not in the setback.
It looked like it
looks-
was.
It's in the setback on the site plan. I just want to confirm that that is in the setback. New construction will be.
No, I think that this is incorrect. I'm pretty sure that deck is inside the setback. I'm not sure.
Propose, it's very close, so let's just say it
It
can't.
will not be.
It will not be.
I think it was this, that is the drawing.
You know what,
That's why it was held back.
Obviously, it wants to be held back, but see, what we're saying is this is the setback line. So I'm just pointing out that this is
Absolutely.
new
Where's
the
construction.
setback line?
The setback line is inboard of
it's a very
the,
small,
so the existing
true
building
building
is,
envelope.
exists and it's going straight up within the setback.
What
which
page
is
are you on,
allowable.
186?
188. And then the deck is actually new construction within that setback. And I just wanted to point
Yeah,
that
well,
out.
if you look at 186, the as-built, I mean, the proposal is different.
186?
It shows it right on the line. Actually, a little out, but I hear what you're saying, Lisa.
I can't find 186.
186 is the.
Oh, this one. Got it.
That red line. I
Okay.
showed earlier too. See how
Yeah.
we've gotten right.
So does that, so this conforms with this?
It doesn't. The 188 does not, it is drawn incorrectly. So
Right.
let's just be 100% clear.
It's
You
not gonna
can't do
be-
that.
It will not be in the setback.
The
So we
new
need a-
deck, even though it's drawn that
And
way.
that's a second floor deck, correct?
It's a second floor deck. We'll end the post.
Well, then these HDC drawings are incorrect because they, it's not as easy as just saying, well, we won't do that because it's outbound of the window now up there.
This is Jeff Blackwell's plan.
Yeah, although Eddie, if you look at the
pretty close.
relationship of the post to the bulkhead, it looks pretty close.
Yeah.
I mean, they might have to take that window and move it a little bit closer. They might want to gang them together so that they have more room, but.
Yeah, but all we're saying to you, Louis, is you can't do that. See, this doesn't encroach.
I know, but see, his plan
Or it
shows it
does,
over.
but-
So you should get a
And then
new
this
plan from
does
him
quite a
that we
bit.
can put in the file that shows it not encroaching within the setback. 'Cause they didn't ask for any new construction outside of the setback, did they?
No, it's just
It was
going
just
up,
vertical
up
expansion.
vertical expansion.
I suppose you could allow that if you
No.
want to. Yeah.
So all we need to do is, if we vote in the affirmative, is agree to the vertical expansion and nothing else. And if they built and they're not if they're in violation of the zoning bylaws, they're gonna have to correct it.
Yeah, but
No.
but we're on the record at this
No new
point saying,
nonconformities will be created. is what
don't
you
do
said.
it. Don't come back and ask afterward and say, oh, it'd be very expensive to move the window, the
Oh, I guess
door,
it's
the
the
bulkhead,
definition
et
of what a new
cetera.
nonconformity
I'll make
is.
sure
It's
that
not
that's
in-
done by
If they
Jeff.
could construct a new deck, it would be a new non-conformity.
Yeah.
as far as I'm
Right.
concerned.
I think the way Eleanor reads that is, it's not getting any closer, so it's not creating a new nonconformity.
It's not a new non-conformity. Again, you're right, it's de minimis over, who knows how much, I can't really tell, the setback line.
Okay.
But it's not closer than that west elevation.
Right. But what we're saying is we don't want any new construction over that setback.
Other than what's going up.
Exactly.
Yeah, because I don't necessarily agree with the notion that it's not new. I mean, it is
Right.
it's not a new nonconformity in that they're already, but it's increasing that nonconformity.
So they're gonna
Because
remain.
it doesn't exist now.
They're
Because
not-
there's no second story on the building.
Yeah.
So they're gonna get a new site plan that shows this not over the setback, just that little line. The dash line is
That
the
upper
setback.
level deck line will be inside of the setback.
But this is the existing, this part is not
Yes.
gonna get any closer
No,
than
the building
4.4 or
on top of what
3.7.
exists.
That's
Okay.
increasing in nonconformity.
Well, yeah, in terms of going up, you're right.
Well, yeah.
Yeah.
I mean.
I mean,
that's-
not really. I mean, you're not any closer to the lot line.
But
But you're
adding-
putting
you're
more
adding-
volume
You're
into
more-
it.
Yeah.
More structure, I guess.
Yeah.
If you
I
look
mean,
at
we're
it that
parsing
way.
the thing pretty tightly at that
If you were
point.
going
No,
up
but we're
under,
talking-
over the envelope that currently exists, then you weren't increasing it. If you're adding a deck onto a second story that doesn't exist, you're increasing the nonconformity if you're beyond the setback line.
Okay.
Anyway,
Okay, anyway.
Lewis has said they're not going to do that, so just make
So
sure.
I just asked for a new exhibit to go into the file.
Mm-hmm.
Right. Okay. New exhibit, but we could take a vote without it.
Yeah, I'm-
We okay with that?
Mm-hmm.
Okay.
Fine with me.
All right.
It will be attached to the decision.
Right.
Yeah.
And he's got a tight window to do this construction, but between the time he actually gets his permit and May, it's gonna be about 4 months.
He's gonna have to get a new phone number.
All right, so just back to the exhibits, though. I mean, we wouldn't necessarily attach these HDC exhibits if they don't correspond.
I'm just looking for the Blackwell plan that shows the deck not over the setback.
Okay.
Mini certificate.
That's all we need.
And it can be, we can just make sure it's attached to the decision.
The HTC plan show.
I can't.
You can't tell, 'cause it doesn't
It's
really show what
difficult
the
to
setback
tell.
is.
I mean, I would say yes, they do, but
But we're not making them, the approval compliant to the HGC elevations, are we?
Only,
No.
we
Well,
should only make
usually-
it compliant to the ridge height.
Yeah.
That's all we should make it compliant to. If we're gonna allow
I
it to
agree.
go up, whatever the
Yeah.
HDC certificate says for ridge height, that's where we want it to be. Other than that, it's really just no new nonconformities.
right. Well, the HDC it would have to be off the application.
Don't we say,
Yeah,
don't
the
we usually
application's right
have
here.
HDC plans and we say in accordance with?
Yes,
or-
we do. That's why I'm bringing it up.
Yeah, but I think from the, as you look at the back, as long as the site plan is showing that the deck is not encroaching, in accordance with the HGC plans, doesn't give him the right to build that deck within the second floor, within the setback.
No.
Yeah, but how many times do people come before us that want to increase ground cover or something like that, and they say, "Oh, well, we have HDC said it's fine," right? I mean,
It's
tell them
just
it's not
hard
fine.
to tell. Is
I'm not saying he has malintent
Well,
or
it's,
anything like that.
it's
I'm
gonna be
just
in the
saying-
minutes of the meeting, I assume.
Right.
do you have floor plans with you?
Yeah.
Yeah, they're in here.
Oh yeah, I have
should
it here.
have them as
I
well.
have
They're
it
in
here.
here.
Yeah,
But it doesn't show the setback.
189.
The setback is shown with depth decimals.
You're right. See, so that,
Well, you could do the math by taking the distance to the corner
Can you read
and
that?
I
no,
can't
it's
read
too
it.
blurry.
4 feet, maybe?
It's 5 feet.
5 feet?
5
Well, he
feet.
has the big ones. Why don't we look at the big ones so we don't go blind?
No, I'd rather.
So
go
he
on.
needs to
wouldn't have to
be
set that
five,
unnecessary.
5.6 feet away. He needs to be, yeah, 5.6 feet away from the corner of the building. So he needs to move that post in. Oh, see, we're just looking at that dimension. So if you're 4.4 feet off the setback there, this post has to be 5.6 feet in from that corner. And I think it says only 5 feet. Right.
Might have to squeeze those windows together.
But that means going back to the HTC.
Well, that's it.
No, I mean
That's
6
what it
inches. We
doesn't
don't. We're
impact
gonna
the
assume it's right, and
vertical,
Yeah. I think we assume that it's right. It's gonna, he can't be over the setback. He'll figure it out.
They'll figure it out.
yes,
Okay.
go back. Yes, go back. Okay.
Okay.
Maybe they just got a pair of French doors up there and not a door and 2 windows. There's lots of different ways they can solve it. so.
I mean, we can say in substantial compliance with the HCC as submitted
As may be amended.
in all in terms of the height
Right,
and with a new site plan.
right.
Yeah,
Okay.
I'm good with that.
Okay.
Okay. And then, is the project have to be complete by
May 1st.
May 1st? Is that the,
What I understood is that we cannot park on the road.
Yeah.
Yeah,
I don't think he has to be
that's
done.
right.
okay.
And when does Nantucket Millie's open up for business? Not until June, July, somewhere in there? So there's plenty of probably satellite parking.
Yeah, down, like I said, down at the beach, there's public parking. Down at the beach.
Yeah.
That's when Nerdist
That's
starts to
when
run
Nerdist
now.
starts.
I know, I get it.
So if we put this condition on no parking, this is enforceable by Marcus?
It's not
After,
enforceable.
say, after May, whatever, say they keep parking June 15th. Marcus enforces this?
Yes.
Well, now let's be clear. It's only you can't park in the street. You're not supposed to park in the street ever.
Yeah, that's enforced by Nantucket Police.
Yeah, wouldn't it just be
Okay,
the
so
police?
why are we including?
Yeah, I don't see
Yeah, I
that
don't
we
think
get
we-
into.
I think that's more of a courtesy of they've expressed.
Yeah,
you
it's a
said
courtesy.
you'll-
It's not
Yeah, you
enforceable.
said you'll do what you can do. I think that's. If they
yeah.
have a problem, they'll call the police. The police will ticket the car. If they
We
do.
know where you live.
All right. I don't think we can get into conditioning where you can park,
I don't either.
although we have in the past asked contractors to.
It's a
Yeah.
courtesy.
OHD,
He's already said
stuff
that
like
he's
that.
going to submit
good
point
with
of
it.
contact. We're good to go.
Let's move
No,
on. All right.
no
So,
knockdown
Lisa, did you
mailbox.
make a motion?
Yes.
To grant the relief as requested, substantial compliance with the HTC,
A new site plan.
new site plan, and we
Nothing
good
else?
with that?
Second.
Alrighty. Who seconded it?
Right here.
Kieran. We'll stick with the regular members. Any further discussion? No. All those in favor say aye.
Aye.
Thank you. Thank you. All right, so other business. The meeting schedule. I'm sure we'll have some problem with some of the dates, but looks fine to me. It's still the second Thursday of every month, right? Okay? So then the final other business, so we're gonna go into executive we're gonna wait for the okay from you.
Yes, you can close.
We can turn the
I'll make a
mics
motion
off.
to close the hearing. Is that what I have to do?
Yep. Kiram seconds it. All those in favor say aye.
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 Well, now we have the board has to entertain, I think before we adjourn, let's scratch that vote.
Oh, we have to.
Before we adjourn, the board may entertain a motion to go into executive session under General Law 30A, blah, 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 for the purpose of discussing strategy with respect to litigation, which are known as One Rugged Scott LLC versus Nantucket Zoning Board of Appeals, Housing Appeals Committee number 2018-01, concerns the denial by the ZBA of a request by Rugged Scott LLC to modify the Beach Plum comprehensive permit so as to allow a garage to be placed on lot 27 Beach Plum, an affordable lot for the benefit of and for the purpose of serving lot 28 Beach Plum, an adjacent market rate lot. And 2, Rugged Scott LLC versus ZBA Housing Appeals Committee number 2018-04, which concerns, et cetera, et cetera, et cetera. So can I get a motion to go?